All right, and as Joe mentioned, Idaho's trigger law has narrow exemptions for rape or incest if the pregnant woman files a police report and gives a copy to the abortion provider. Now, there's also an exception for providers who are able to prove in court after performing an abortion that it was necessary to save the mother's life. But how does a doctor determine that? Our Morgan Romero talked to the University of Idaho's constitutional law professor, Shakira Sanders, about this clause in the law, and she says it's still very unclear.
This section of Idaho's abortion ban outlines when a doctor would not face a felony charge for providing an abortion. The provider has to have an affirmative defense proven in court by a preponderance of evidence, meaning they have to prove it's more likely than not true that when using good faith medical judgment and based on the facts known to them, the abortion was necessary to prevent the death of a pregnant woman. Under Idaho's law, an abortion is not seen as necessary when a doctor believes the pregnant woman might hurt herself.
Now, the court hasn't really done a lot of work by taking cases to evaluate exactly what that standard means. And it is unclear to me whether this is just a decision between the doctor and the patient, or if I don't believe Idaho has a law on the books that exactly details what type of medical conditions that we are talking about. And here in particular, there is an overwhelming amount of empirical work that has demonstrated the high disparities of medical issues when it comes to childbirth for women of color. It is not exactly clear to me when we're talking about health, safety, life, if we're talking about catastrophic incidents or occurrences, and this type of law could find itself winding its way through Idaho courts, where it could ultimately be decided, because of course now the US Supreme Court has said that this is an issue for states.
So you feel like this language in Idaho's law from 2020, basically saying that it's up to the doctor and his good faith medical judgment based on the facts presented at the time, that's very gray.
Yes, in terms of particular situations. And again, more importantly, the idea that a woman would not be able to obtain an abortion because her illness or the danger to her would be through self-harm. Well, that is a symptom of a multitude of pretty severe psychological medical disorders.
Is this something that you anticipate a doctor may just say, I don't want to touch this because I don't want to have to prove this in a court?
I don't know what to think. I'm not a member of the medical community. That to me seems to be such a specialized area of care when you're in these situations where a woman's life is at risk for some reason related to her pregnancy, where terminating is the most viable option of keeping her alive. I don't know what that world is like. And it seems like it is very unlikely to me that any doctor would have the time to seek redress in the court on this. And so what we will know and how long it takes us to learn it about how abortions, if anyone's providing them, how they're operating in this space, very troubling that this would be such a gray area.